On Radio 97, let's talk law. Let's learn a couple of things, as we always do every Thursday morning, about the law. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us every Thursday to offer her legal expertise. She provides some general advice on the latest hot topics. She has experience that spans more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. She's with us this morning. Hello, Despina.
Hello, Wayne. Hello, Brooke.
Good morning, Desi. Alrighty, so this morning we're going to start off by talking about something I don't know too much about. I'm so sorry, but probate. What is it? How does it work? Hopefully I'm not alone in asking what is the definition? What is probate?
Yeah, look, and don't feel bad about that because probate is really about deceased estates. So unless, you've been involved with someone's passed away and you're actually actively involved in their estate, you probably really won't know what probate is. So putting it really simply, probate is where someone's passed away and you've got an estate to deal with. And hopefully there is a will lying around that is that's a valid will, and that can be located. And when we talk about probate, we're talking about making an application to the Supreme Court to basically get that last will recognised by the Supreme Court as the last valid will of the deceased. So that's what probate is referred to and what it means in a nutshell. And there's lots of things and there's a process by which you have to follow to make the application and to the Supreme Court and get that seal of approval, if you like to call it. So when you get the will back from the court, presuming they actually recognise it as a valid will, you get this big red seal of the Supreme Court and it's stamped on the front of the will. And then anybody who sees that will obviously know that probate's been granted.
Wow. So it sounds like a movie. There's a big red fancy seal that goes, yep. It's the money's in it. It's good to go. That's so interesting. So what is it then about probate? Obviously, we're talking about it for a reason. What is it that people don't quite understand in that process?
Okay, so there's lots of things. So first of all, do you need it? Okay, so there's a question of, do you actually need to get probate? And if you don't really need to get probate, the other question is, should you get probate? Okay, so that's something that really needs to be determined right at the beginning when someone comes to you, presumably the executor that's been named in the will, or it could be next of kin, who just need to know what's going to happen now. This person's passed away, they've got all these assets, do we need probate? And then we talk about the process and whether we do. Now, as to the need for probate, typically what we find is the benchmark comes down to the value of the assets. And now the benchmark seems to be if you have more than $50,000 value in any given asset. For example, a bank account that has more than $50,000 or shares that are worth more than $50,000. So that seems to be a benchmark. Generally, that's used by banks and other institutions. So when you write to them from the beginning, and you say, okay, this person's now died. What are your requirements to either close the account or say to get the shares sold? Or if you're dealing with superannuation, which we've talked about recently, and there's a superannuation death policy, you write to the company, the fund, and you say, what are the requirements to have that paid out? So it really comes down to third-party requirements. And as I said, it's the value of the assets. So say if you have our assets that are worth more than $50,000, then you go, okay, well, if that's what they require, we then have to start the process of making the application. And before we talk about that process, we want to answer the next question, or the second question, which I mentioned is, if you don't actually need probate to collect all the assets, pay all the debts and distribute the monies to the beneficiaries owed, should you get probate? And that's a really important question to answer, because there are benefits to getting probate. So if you think about the process, it's an application made to the Supreme Court, and to be able to lodge documents in the Supreme Court, you have to actually advertise. So then there's notice to the world at large. Number one, the person's died. Number two, if you want to make a claim against the estate, well, you better go do it, because we're about to get probate. and we're about to distribute the estate down the track. So it's noticed to third parties at large, creditors and the like, or people who want to make a claim, that this is happening. It's in the process. So if you go through the process, you get your probate and no one makes a claim and no one puts their hand up as a creditor to say, I'm owed money from the person who passed away, then as executor, you are safe to then distribute the monies down the track because you've done everything right and you've covered yourself. You've given people time to make claims because you've notified to the world at large, this person's passed away, we're applying for probate. So if anybody wanted to make a claim, they have their opportunity to do so. And if they didn't within the time frames within each state, then the executor is safe to distribute the monies. Wow. And so he won't be held personally liable, for example, if he did the right thing or she did.
Now, Despina, who makes the call as to whether a will is worthwhile being put into probate? Is it one of the other potentially, I guess someone who wants part of the will, or is it the banks? I mean, who can make the call? Who does make the call?
So, as I said before, what you need to do straight away is figure out where are all the assets held. So hopefully the family, the next of kin, will know exactly what the deceased had. Then you write to all the banks, you write to other institutions, you write to the share companies, you find out what are their requirements. Now, if just one of them writes back and says, we need probate before we're going to close this account and give you the money, then you know that you've got to get probate. But as I said, even if none of them require probate, sometimes we say to executors, you know what, you're safer off getting the application or making the application and getting that probate, so you are covered. So you've done this process of notifying third parties because you put the advertisement in a publication that we're required to do, and then you've given people that time frame to make a claim. So if you don't do that and then you just go and distribute, there could be lots of problems for the executor down the track.
Okay. What about timeframes you mentioned? Does it vary from place to place? What time are we looking at?
Yeah, really good question. So in Queensland, we have, and New South Wales are a little bit different, but essentially anyone's got about 6 months from the date of death to notify the executor, look, I think I'm going to make a claim. I'm not really sure, but I think I am. I'm going to put you on notice. So that's in both New South Wales and Queensland. But the difference is in Queensland, they've got to actually file an application within 9 months from the date of death. And in New South Wales, it's 12 months. So if an executor gets that type of notice, even if they did get probate, even if the will's been probated and it's been sealed by the Supreme Court, if there's notice given, the executor can't do anything until that claim is dealt with. So those are the timeframes, yeah. And the other interesting aspect to what we call probate is, it's a formal application to the Supreme Court, but that's assuming there is a will around, and that's assuming the will is valid. What if there isn't a will? So what if the person passed away and had all these assets? They're valuable, they're over 50,000, and there's no will.
And of course that does happen, doesn't it?
Of course it happens, because people invariably don't make wills. And I've said on the show so many times, you're over 18.
Go make your will.
I know, go make your will. You're over 18 years of age. Make sure it's done and it's in place. So, but people don't do it. I think people think it's a sign that they might, something might happen to them.
They're jinxing it.
They're going to jinx it, but it's really the wrong way to look at it. So anyway, so if you don't have a will, then you have to make a similar application, but it's called letters of administration. And that's a little bit more complicated because you've got to then, if you don't have a will, you don't have an executor that's named. So you don't have someone who's been given the right to administer the estate. So then you've got to go and hunt down who is the next of kin. And there is an order of a next of kin as who is allowed at law to make the application. And then you've got to find them, you've got to locate them. Are they alive? Are they passed away? If they've passed away, you've got to prove that they've passed away to let the next person in line come through and make the application. And definitely if there's no will and you've got some considerable, assets, you really should be making this application without a doubt. So it's all very interesting. And look, we deal with probate applications all the time, both in New South Wales and Queensland. In actual fact, we get a lot of New South Wales law firms that ask us to do it because it is quite a different process from New South Wales to Queensland. And the other interesting thing I should say is that if you get probate in New South Wales because you have New South Wales assets, and you have Queensland assets,
yeah.
then sometimes you might need to go and prove that will again in the Supreme Court in Queensland. So, yeah.
Such a big process.
Well, it can be. I mean, the application itself for probate, if you've got a will, is relatively simple. You've got your applications and affidavits to be made. You've got to advertise correctly. So, but it's got to be done right. So you've got to dot all the I's, cross the T's, so it's accepted by the court. Yeah.
Despina, is there a cost involved?
There is. So you've got advertising fees, and then you've got the Supreme Court filing fee. Yeah. And you know what's really interesting, a lot of people may not be aware, if the deceased was on a pension at the time that they passed away, you can actually get a discount on the Supreme Court filing fee. Well, you can in Queensland. You can in Queensland.
You said Supreme Court filing fee as if it is quite expensive, the tone of your voice. How much are you talking?
Oh, I think at the moment, don't quote me, because the fees all went up, I think, 1st of July. But look, it's in the range of $700, $700, $800. And then the advertising's $200-300. So we typically say, look, you're going to be at least $1,000 just for the outlays, nothing to do with legal fees. So if you can get a discount, and it's a considerable discount on the Supreme Court filing fee if the deceased was a pensioner, and you can prove that, then why not?
So interesting. There you go. I now know so much about probate. Thank you so much, Despina Priala. And coming up next, we're talking about the infringement fees that have just been bumped up and up and up in Queensland. That's coming up next on Talking Law. You're listening to Radio 97.